Welcome back to Winning Isn't Easy. How AT&T justified a denial of an ERISA disability claim of a multiple sclerosis patient because of their subjective pain. MS can damage the myelin sheath of a nerve, and it can cause acute or chronic neuropathic pain. I think of the myelin as the basic electrical insulation on nerves, if you will. So you think of a electrical wire, it's got this insulation. If you peel back the wire, it's a live wire. Same way, I think, in the context of MS. Now, this chronic or acute neuropathic pain can feel like cramping, squeezing, pulling, burning, stabbing. And it can also be musculoskeletal in nature, and it can be spasmodic. It can involve every part of your body, including your eyes. According to research, at least 75% of patients with MS will suffer pain, and that's also treated with antidepressants, anticonvulsants, and other medication. These complaints are considered subjective in nature. So how do disability carriers or plans evaluate subjective multiple sclerosis pain? And answering that question, I'm going to tell you the story of Imran Khan, who worked as a customer service representative as AT&T. He was covered under their disability plan. He filed a short and long-term disability claim because of the pain associated with MS. His claim was denied on appeal, and he submitted an affidavit from his treating physician who opined that the subjective complaints did not, and severity of his pain didn't really equate with the physical findings. But the doctor felt that the multiple sclerosis was a contributing factor in the severity of his pain. And he had the symptoms that could be consistent with MS. Now, that wasn't particularly helpful. What the doctor should have said is, look, he does have subjective complaints, and the severity of the pain may not necessarily be consistent with the physical findings, but we don't necessarily expect that in MS cases. We do think that MS is a contributing factor, or the cause of his disability and his inability to do his own occupation. And weaving into that letter, the other symptoms of MS that were consistent with the diagnosis and objectively found on examination, such as spasm. Now, notwithstanding that not so helpful opinion, the doctor also opined that he was completely and totally disabled. That doesn't necessarily help because the disability carrier wants the doctor to fill out APS forms to document the actual restrictions and limitations, not that the person is disabled. So the AT&T plan had his medical records reviewed by a consulting physician who, of course, opined Khan was not disabled and said, look, there are not enough significant clinical findings to support the restricted work activity or even in the opinion that he's unable to work. And there's no evidence of impingement. Now, you wouldn't necessarily see evidence of impingement in an MS case. You might see impingement if you have a herniated disc where the disc is impinging or pressing on a nerve root. And you can actually document that by having an EMG, a nerve conduction study test. Now, in this case, Khan continued to get medical treatment and he continued to complain of problems, including problems with his spine. So he got worked up. The MRI was normal. The physical exam didn't show evidence of limited range of motion, decreased strength, or mobility issues consistent with a spinal condition. So once again, AT&T peer-reviewed doctors noted that while Khan had subjective complaints of pain that caused functional limitations, objectively, he didn't have neurological deficits or specific findings on physical exam. Ultimately, the case ends up in front of a federal judge who notes that Khan has the burden of proof. Now, what did the federal judge do? Well, Khan argued that the plan didn't consider his pain associated with the MS, and as a result, the decision was arbitrary and capricious. But the court said, well, we can't accept that argument because the AT&T physicians explicitly acknowledged his subjective complaints of pain, but across the board found that the objective evidence didn't corroborate his reported pain and functional limitations. In other words, there was a failure of proof and the denial was upheld. Now, I will tell you, that part of the problem in this case was that Kahn didn't submit the right proof from the right doctor. What do I mean? So what proof should Kahn have submitted? Part of the problem was that he was seeing a primary physician and not an MS specialist who could have had him undergo the MRI to confirm the MS diagnosis and correlate the lesions with the complaints. There are protocols and testing to objectively document MS neuropathic pain, which wasn't done by Kahn's physicians. So one of the articles that we will submit in MS cases if there's this issue is an article found in Neuropathic Pain and Multiple Sclerosis, Current Therapeutic Intervention and Future Treatment Perspectives. It's found in a November 27, 2017 publication, and I'm not going to go through who the editors were, but in any event, the publication talks about how physicians will typically assess an MS patient's pain through medical history, conduct a physical exam, and the article suggests quantitative sensory testing pain, including evoked potentials and skin biopsies to diagnose and document the neuropathic pain. The article also suggests that there is a 3-level grading system to document the neuropathic pain. First, the physician is to assess the possibility of neuropathic pain by taking a history from the patient who has to have a history of a relevant neurological lesion or disease, i.e., confirmed generally by an MRI, and the pain distribution reported by the patient has to be consistent with the suspected lesion or disease. So you need the MRI, you need the lesions, and you need to have the lesions correlate with the location and nature of the pain that's being reported. Next, the article suggests that there has to be a physical exam of sensory function to ensure that the pain associated with the sensory signs are in the same neuroanatomic distribution. Now, this exam should document musculoskeletal pain and functional restrictions. So in other words, in essence, in English, you got to start connecting the dots. And then third, the patient should undergo the diagnostic studies to confirm the disease or lesions and the neuropathic pain. Again, another objective way to connect the dots. Since Kahn was not seeing a specialist, none of this was done, and there was no pathology to correlate with the severity of pain defense that should have been addressed by Kahn's physicians. You can see that before you stop work and apply for benefits because of MS, you really should be reviewing your medical records and the policy of the plan to understand what proof needs to be submitted. It might be that you have to delay your application so that the medical proof can be properly developed, so your claim isn't denied like Mr. Kahn's was. Again, we analyze the medical records, the policy, and the plan, and we come up with a strategy to make sure that we are addressing the potential objections that a carrier might have or a plan might have because of the lack of medical documentation of the diagnosis, the lack of medical documentation that correlates the symptoms with the diagnosis, the lack of medical documentation that explains functionally why the neuropathic pain or other complaints are consistent with the diagnosis and the level and severity of the impairment. You can see it takes a teamwork to get your benefits. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed the episode, please like it, leave a review, share it with your family or friends, and please subscribe to our podcast. That way you're going to be notified every time a new episode comes out. I hope you tune in next week for another insightful episode of Winning Isn't Easy. Thanks.